Can Ripple beat the SEC? When will Ripple present new arguments in its defense? How much will XRP cost after the trial ends? We will answer these questions in today's video. In the meantime, subscribe to the channel and we're getting started. Maybe not what Brad Garlinghouse had in mind when he joined Ripple Labs as CEO in 2015 is to become a pivotal character in one of the largest legal disputes in the history of Bitcoin. Garlinghouse has extensive business experience and is no stranger to tussling with authorities. Hutchinson, Kansas, is where Brad Garlinghouse spent his formative years. Garlinghouse cites his childhood in a tiny town in the Midwest of the United States, where he learned the importance of family and community. Garlinghouse, a college student who was eager to build his resume, interned at various prestigious companies throughout his time at university. Garlinghouse started his successful financial career as an analyst at JP Morgan after earning his MBA from Harvard Business School. At this time, Garlinghouse was exposed to some of the most influential people and organizations in the business world, including those on Wall Street and at the World Economic Forum. Despite his many contributions to Yahoo, Tim Garlinghouse will always be known for writing the Peanut Butter Manifesto. This now famous internal Yahoo document critiqued the company's methods and called for more productivity. Everyone in the financial technology sector read the memo. Prior to entering the blockchain and digital asset industries, Brad Garlinghouse worked as an investor with Silver Lake Partners. To fulfill his role as managing director, Garlinghouse researched companies including Dell MC, Airbnb, and Alibaba Group for possible investment. It was at this time that Garlinghouse served as a senior executive at Hightail in addition to his other responsibilities there. By renaming Usendit to Hightail, Garlinghouse made sure the firm kept its promise to serve its global clientele with innovative productivity solutions. Hundreds of financial institutions across the globe already utilize the Ripple network to make instantaneous international money transfers. Throughout this period, XRP has surpassed other altcoins like Ethereum and Cardano in market capitalization, making it one of the biggest cryptocurrencies on the blockchain. Garlinghouse has often discussed the present state of banking rules and cybersecurity challenges, highlighting blockchain as a possible solution. Because of his outspoken views, the SEC now considers him a potential target in their continuing battle against cryptocurrency. The SEC's complaint against Ripple Labs casts a pall on the CEO's tenure as head of the blockchain company. The action seeks to clarify the SEC's position on the status of the XRP cryptocurrency. According to the SEC, the XRP coin is a security, although Brad Garlinghouse and Ripple Labs see it as a money. Damage to Ripple Labs and XRP from the litigation has been extensive, with the currency being delisted from major trading platforms like Coinbase. Fear, uncertainty, and doubt have clouded XRP's future, reducing its trading liquidity and preventing it from reaping the full benefits of previous bull markets in the first part of 2020. 3. We should get a definitive verdict on this matter. The SEC isn't stopping there with its onslaught on the blockchain and cryptocurrency sector. Kraken was fined $30 million by the SEC in February 2023 because of issues with their staking offering. According to attorney John E. Deaton, the only success the U.S. Securities and Exchange Commission is likely to claim in its lawsuit against Ripple is that the blockchain payments business offered XRP as a security from 2013 to 2017 to 2017. In a long Twitter thread yesterday, the lawyer representing over 75,000 XRP investors, as a friend of the court in the matter, explains his argument. Deaton says in the thread that the market regulator failed to perform a particular Howey analysis by naming transactions that resembled securities offers. Instead, he claims the market regulator is attempting to employ the equivalent of a but for tests to declare that all XRP sales are security. The SEC's argument, according to Deaton, is that since Ripple made an attempt to assist develop a secondary market for XRP, all XRP constituted securities regardless of the circumstances of the transaction. This is based on an allegation made by the SEC in its summary judgment request, according to the lawyer. Defendants do not dispute that they offered and sold XRP in return for money, which suffices to show the investment of money's component of the Howey test, according to the SEC. Defendants' remarks and activities about XRP Gelly demonstrate the other components of the Howey test. In tort and criminal proceedings, the but for test is widely used to establish guilt by demonstrating that an outcome is the consequence of a party's behavior and would not be the case if the party had behaved differently. Moreover, Deaton claims that the SEC places disproportionate emphasis on the token XRP in order to avoid a true Hawaii examination. According to the lawyer, the market regulator contends that XRP reflects both the investment contract and the joint venture. The lawyer objects, pointing out that this is not how Hawaii is used, since the conditions of the transaction normally decide whether an offering is an investment contract. Remember that Deaton has often said that the underlying asset of an investment contract cannot serve as a security on its own. Significantly, according to the attorney, he persuaded the court in the Lullby case of this, compelling the SEC to agree to it on the record. As a result, the attorney feels that the SEC may have had a simple and winning case if they had undertaken a comprehensive Hawaii analysis informed by the facts of the sale, which would have narrowed things down to particular transactions rather than all XRP sales, as it presently maintained. This is why I suggested the SEC may have grabbed defeat from the mouths of victory, Deaton commented in the thread, noting that the SEC's allegations in the Ripple case are arguably the largest and most far-reaching the agency has made in any enforcement action. Since both sides have filed all needed documents in the case and await a court decision, speculation about potential outcomes has dominated talks. Deaton has said that a jury trial is most probable. Ripple's A22, David Schwartz, has become a Twitter star. In a tweet yesterday, the Ripple executive and XRP Ledger creator made a comment about peeing in a pool, provoking the backlash. "I was assured that as long as nobody is particularly close to you in a pool full of people, nobody would know that you did," Schwartz writes. "I realize now that this only applies if you're in the pool." The crypto and XRP communities have reacted in force to the amusing tweet. A few Twitter users thought that the Ripple executive's comments may have some hidden meaning. As a consequence, efforts have been made to create ties to liquidity sources. Unfortunately, no such evident relationships seem to exist. It should be noted that, as previously stated, XRP Ledger developers are now testing a native automated market maker, AM. Schwartz believes that the AM's qualities, such as the ability to provide single-side liquidity supply, distinguish it from other comparable products. Those who thought the joke amusing but could not see any deeper meaning uploaded tales and memes in response. Nonetheless, the tweet has received appreciation from an unexpected source, Cardano developer Charles Hoskinson. It's also worth noting that Hoskinson's relationship with the XRP community is strained. Notably, he has previously clashed with the community over statements he made about the alleged Ripple settlement date and comments he made concerning the relationship between officials at the U.S. Securities and Exchange Commission and Ethereum. Hoskinson said in December that he would no longer be making remarks on the matter due to the toxic and petty attitude of the XRP community. Furthermore, he said that he had no qualms about terminating relations with the community since XRP had no technical or financial value. Ripple to David Schwartz and Bitcoin supporter Demester recently had a Twitter dispute over whether Ethereum, ETH, was preferable than Microsoft. Miss Thief's shares. Demester initiated the debate with a tweet on the Hawaii test, a legal criteria for establishing whether or not an investment is a security. Demester stated that ETH meets the Hawaii test because it is a pooled investment in which the profits are dependent on the efforts of others. "I'm not sure I understand what you're saying," Schwartz remarked. "You assert that ETH represents a joint financial investment in a joint venture. They acquired their ETH directly from ETH, you say?"